Can a defendant truly prove they couldn't have committed a crime while simultaneously having no physical evidence of the alleged action? This case centers on a complex pre-trial motion hearing regarding potential charges against Ms. Callahan. In this session, the court navigates scheduling conflicts, challenges evidence regarding Ignition Interlock Device, IID, results, and sets the path forward for the legal proceedings.
Mr. Lap.
Okay. Morning, Mr. English.
Good morning.
And
Your Honor, I'm making an appearance under 3.4. I talked to my client earlier today and talked about the game plan. He would like to waive his right to a speedy trial. An offer has been extended, but we need a little bit more time to discuss all of his legal options.
Mr. Clark, your thoughts on this?
I'm sorry, what was the question again, Your Honor?
This is number 5, Mr. Lapp. Mr. English is asking for a continuance to consider an offer that has been made.
Yeah, no objection, Your Honor.
And Mr. English, have you submitted a waiver?
I have. I emailed it to the website listed on the county. I'm sorry, the email listed on the county website. DC PDFs for court.
Was that today?
Correct, in the morning. And the commencement date is today, with an expiration date of July 14th, I believe.
Yes.
And if I could request a return date of May 20th at 1:30 p.m.
All right, we're going to check that date and time for you. All right, Mr. English, on Mr. Lapp's case, we'll strike the jury panel today, reset this for confirmation on May 20th at 1:30 p.m. We'll have jury dates of June 1st and 2nd in the event that they're needed.
Okay, that'll work. Thank you.
All right, thank you, Mr. English. That takes
Thank you,
care
Judge.
of that matter.
I also have a couple
Callahan,
of
are you
other
back?
matters.
Yes, Your Honor.
Mr.
I'm
English,
back.
I'm trying to finish a matter here that we started with Ms. Callahan a few moments ago. She's
Sounds
back on
good.
screen, so I want to go there and then I'll come back to you.
No problem. Thank you.
All right, Ms. Callahan, go ahead.
Thank you, Your Honor. We stand on the evidence that we provided.
When a defense attorney asks for time to review a plea offer, they are exercising their right to explore all possible legal outcomes before agreeing to a deal. This strategic pause is crucial because the defendant's choice impacts everything from their record to their future liberty. The process ensures that any plea is fully considered, adhering to procedural fairness.
And my arguments, Your Honor, it would not be possible for her to be obstructing her scram for 3 days straight and drinking. But at the same time, and these, the IID takes a photo of who's blowing, but at the same time have no failed blows on her IID. And despite of the, I'm sorry, I don't have his name, but with all due respect, the prosecutor who's in his hearing, that is evidence, that is proof. The time card proves she was working on those dates of the scram violations. She's going to show up for court as a nurse at a hospital drunk? No. So the evidence is on her side, and I would ask the court to go with your original decision in this matter, and I'll leave it at that.
Well, my original decision was to follow the request I thought you made previously, which was that you were going to get some additional information to submit to the court from the IID provider.
I will do that, Your Honor. Yes.
All right. So what we'll do today on the Galena matter is we will strike the jury.
The defense is essentially raising a factual inconsistency. How could someone allegedly tamper with a device for 3 days without the device recording any failures? This challenges the prosecution's narrative, forcing the court to scrutinize the technical reliability of the evidence presented, which is a key function of pretrial motions.
Panel today. We'll reset this for another hearing on the pre-FTC or on the motion to revoke conditions in this case. I'm going to find good cause to extend the time in this matter based on this motion and the state's insistence on going forward with its motion, which is fine. But again, I know Ms. Callahan, and I know that I have been in this business long enough to know that the business of recording ignition interlock device results is difficult at best. So if there's other stuff out there for the prosecutor to consider and for the court to consider, we should have all that before a decision is made on that. So,
In particular, Your Honor, if I may, just briefly, if the prosecutor can show how it would be possible to obstruct her scram for 3 days straight by drinking, but have no failed blows. I mean, that's the crux of the matter. You can't obstruct your scram. It's tight to your ankle. It's skin tight, so tight that most people get welts and have problems with swelling. So anyway, I would thank you, Your Honor. I will get additional information from her IID provider.
all right, let's get you a date.
Mhm.
Hold on, we're looking at it. I don't want to go more than a month. Not more than a month. No, we can quash the warrant. She was here today. I'm satisfied that that's okay.
Your Honor, or may I just, the clerk? I just want to let you know that I have I'm sorry. In the month of, I apologize. So we are looking at May. Is that correct? Or June? Madam
We're
Clerk?
looking at May.
Say it again, Your Honor, May? Okay.
Yes, May.
Okay, I have a meeting I have a Zoom hearing in the morning. I don't know how long it's going to be. On the 1st, I have an in-person at Hoquiam Muni on the 5th. That's an all day with travel. On the 6th, I have Zoom meetings. Looks like they're at your court, so we could add it there, I suppose. I have 3 pretrials that day. 7th and 8th are open for me. I have an RJC King County Zoom on Monday, the 11th. Pardon me. My calendar doesn't want to work now. And I can't tell you. Let's see.
But
Okay, here we go. Yeah, toward the end of the month, I'm open. After
18
I'm open, yes.
conditions. All right, Ms. Callahan, here's what we're going to do.
Mhm.
First, we're going to be a jury panel in this case. Second, I will quash the warrant in this case based on your appearance and your client's appearance today and filing some initial response to the motion that the state has provided. Reset this matter. I'll make a finding of good cause to reset these matters without violating the speedy trial rule. And we will reset this for confirmation and conditions hearing on Monday, May 18th at 10 a.m. And then we'll have jury trial as a backup in the event that it's necessary on the 27th and 28th of May.
Okay.
I think that takes care of all the issues that need to be addressed today.
I think so.
And reset dates.
Okay, Your Honor, I may be requesting a continuance of the jury trial and confirmation. All my time is going to be put into finding the witness and a witness on this. So, but thank you, Your Honor. We'll
Yeah,
We'll-
we can't fix
we'll
all
be
the
fine.
dates today, but we've done the best we can.
Exactly. All right. Thank
All
you
right,
very
Ms.
much.
Callahan, thank you for being here. Ms. Galena, thank you for being here. That's all for
Thank you,
today.
sir. Okay,
Thank
thank
you.
you, sir.
Mr. English, you still with us? All right. So to the 9:30 calendar, number 1 is Tumwater versus Emily Diaz, DIAZ, case number 26-M00089. Mr. Rusk is the attorney of record. Mr. Rusk, good morning.
Good afternoon, Your Honor. Tim Rusk on behalf of Ms. Diaz. This is a first pretrial hearing, Your Honor. I've consulted with my client and she's requested that I continue this on her behalf. She has a new job and a mandatory training today, which is why she's asked me to appear for her. We're seeking approximately 30 to 45 day continuance in hopes to bring this to
The court struck the jury panel for the day and issued a finding of good cause to reset the case without violating the speedy trial rule. The matter is now scheduled for a confirmation and conditions hearing on Monday, May 18, 2026, with jury trial dates set as a backup for May 27th and 28th. The defense successfully secured a necessary continuance to gather more information regarding the IID provider's data. This case highlights the critical balance courts must strike between the state's need to proceed and a defendant's right to a thorough defense. When evidence is complex, like IID data, judges can grant continuances to ensure all facts are properly presented before making a final decision. Subscribe now to follow more deep dives into how the legal system works.